Hi friends, so in this video we'll see a video about investigation. So in investigation section 206, first scrutiny of accounts will be done by ROC. Then if ROC has found some things, then they can even ask for inquiry of past and present employees. So if they are not finding that information from the employees satisfactory, then they can ask for inspection. Then they can go for inspection. So even if they can write a letter to central government if there is a fraud involved, so they can write a letter to central government that there is an involvement of fraud here under section 208. In section 207, inspection will be carried out. They will come to the office of the company. They can have a copy of records. They can even place some bookmarks. Then section 209, they can come and do search and seizure of accounts. So that seized accounts can be kept for approximately 180 days. Then section 210, central government investigation. Central government will order for investigation on receiving the report from ROC. Number 2, central government will order for investigation if there is a special resolution from the shareholders. Number 3, on suo motu, central government can go for order for investigation. Then section 211, excuse me. Section 211 is investigation by SFIO. So we have to first, central government will be first setting up of SFIO. So they will be having thorough knowledge in field of banking, commerce, information technology, laws, etc. And they will be holding the position of secretary, joint secretary rank of central government. They have a right to arrest a person even without warrant. So this is section 212. So how they will arrest, and there will not be any bail also. So it's a non-bailable offence, that is cognizable offence. But 3 persons can be given bail. One is juvenile, another one is woman, another one is juvenile, woman and sick person. So there will be a question whether a person who's a minor, whether he can get bail if he is arrested with a serious fraud investigation officer. In institute answer, they told minor can be given bail because he is a juvenile. I will tell you, there is a act for juvenile. It says minor is different and juvenile is different. A person of 16 to 18 years is not called as juvenile. Even though he is minor, he is not juvenile. So only less than 16 years will be called as juvenile. Then minor can even be arrested. Okay, you should write like that. This has been latest amendment in the Juvenile Act. It's not in Companies Act. Then section 213, investigation by NCLT. In case the company is having share capital 1/10 of the person who is holding a share capital. In case the company is not having share capital, 1/5 of the voting power. In numbers, it is 1/10 or 100, whichever is less in numbers. They can ask for investigation. Then this is 213. Then 214, only individuals can be appointed as this investigator, the inspector. So a firm or body corporate cannot come. And 215 says like anyone who have to come for means like who ask for investigation, they should submit a deposit. It varies up to ₹25,000 rupees, and this deposit is refundable deposit in case if the if they are proved that they are guilty, then from that person we will be taking the money and it will be given refunded to the shareholder or any person who asked for it. Then section 216, we will be lifting the corporate wheel. So we will be seeing the real ownership of the company. Real ownership we will see, looking into the real ownership of the company by lifting the corporate wheel. Then 217, powers of inspector. Inspector has powers like summoning, enforcing attendance, examination on oath, taking affidavit, passing ex parte order. And section 218 says in case if the employees are cooperating this investigation, and because of them the company will get irritated. So the company, whether they can fire the employees? Answer is no. They should get prior permission from the NCLT before firing the employees or depromoting them. So it's a safeguarding of employees. If NCLT is kept silent in 30 days, then the companies can go forward for firing the employees. Then the next topic is whether the employee can go for an appeal. Strictly speaking, as per the act, the employees cannot go for an appeal, but companies can go for appeal within 30 days by paying 1000 rupees. Okay, so the appeal fees is 1000 rupees. But in one of the ICA answer, they told employees also can go for appeal. I think that question is Ampreet or Arpit. Some question is there in ICA practice manual or some such answer. That question is actually, the answer is wrong, because as per the act, the employees cannot go for an appeal, but the companies can go for an appeal. Section 218. Then 219. 219 is related party investigation. So the company which has swindled the money, it can be routed through some holding company, subsidiary company, or other companies. So all these companies can also be inspected or investigated. Then 220 again seizure of books. Then 221 it is like properties will be seized. Then 222 is the securities, they cannot transfer the securities. None of the shareholders of the company can transfer the securities to other persons. Then 223, the inspector will be writing the report. It will be in paragraph wise, and it will be printed in the letterhead of the company, and it will be sealed by the inspector. Then it will be sent in a sealed cover to central government as well as NCLT. So all his findings will be marked here. Then 224, based on this, central government will take some actions. Then whatever expenses they have incurred for 225, the expenses will be reimbursed, because the inspector will be spending some more expenses. So all these expenses will be given back to him. Then 226 is not there. 227, 226 is like winding up. Okay, this like inspection or investigation will be carried out even at the time of during voluntary winding up. So winding up will not stop investigation. Then 227, we cannot inspect two people. One is this bank, and another one is this legal counsel. So the legal representative and banks people, they cannot be inspected by this inspector. Then 228, whatever we are studying in this section, it's all applicable to even foreign companies under section 228. Then 229 is penalties for non-cooperating in inspection investigation. So this is what inspection investigation chapter. Then we'll go for foreign company chapter. Section 379 talks about foreign company. In this you have applicability of this entire act to the foreign company. In case if only the company is satisfying the definition of foreign company, section 2 subsection 42, it says a company is incorporated in abroad and having place of business in India, then it is a foreign company. There are some companies which is incorporated abroad having place of business in India, but in the abroad company itself, Indians having more shares, like say Jaguar cars. So Tata is controlling Jaguar cars, then Cora Steel, etc. So those kind of companies, if they have branches in India, business operation in India, it will be called as Indian company. Even though it is not registered under Indian Act, the entire Act is applicable under section 379. If 50% or more of the share capital is held by Indians, Indian body corporate, or combination of both. Then section 380 says documents will be submitted. There are like MOA, AOA of the parent company, then constitution under which the parent company is established, number of branches in India, then directors numbers, then passport photograph, details about directors, then authorized representative in India, then authorized representative, company secretary, then if previously if they came and operated in India, then those details. All these things has to be given in form FC1. If it is not in English, then translate in English. Who has to do translation? Authorized person. Authorized person means who? Notary public and apostolization in case of it's abroad. it should be also get signed by embassy, local embassy, abroad company's embassy will be there in India. No, that company's embassy has to sign. So this is how the translation should be done in case if it is not in English. Then it should be filed in form FC1 within 30 days of having a branch in India. Then if there is any change, there should be FC2. Within 30 days also they should file. Then section 381, books of accounts has to be kept. Then financial statements has to be made in accordance with schedule 3. So you should comply with section 128 and 129 and schedule 3. Then more particular disclosure, two disclosure has to be made. Disclosure number 1 is related party transaction, and disclosure number 2 is repatriation of profits. So you should write like who is the beneficiary, what is the currency in which you are repatriating, then to whom it's repatriating, which country it's getting repatriated. Then in case of related party, nature of transaction, nature of relationship, amount, all those things has to be disclosed. Then 382, it's like the company should have a board. Every branch they should have a board with English language and vernacular language. Then 383 is like authorized representative. In case if there is any notice to be served on this foreign company, it need not be served on the foreign company because we don't know exact address, etc. And it's in abroad, etc. So what we can do, we can serve this notice to the authorized representative of the company. It's enough if it's sent to authorized representative, it is enough that it is served on the foreign company itself. Then this is 383. Then 384, debentures, annual returns, charges, inspection. So for debentures, section 71 of the Indian Companies Act is applicable. Then charges, you have to follow this chapter 6 of Indian Companies Act. Then in inspection investigation, you should follow that section 206 to 229, whatever I discussed now, that has to be followed. Then annual return has to be submitted within 60 days of the end of the year. Then 385, whatever the fees requested by ROC, it has to be given to this ROC for filing certain documents. Then 386, 387 is like dating of prospectus. Dating means like every prospectus before it is issued to public, it should be dated, and 3 points to be noted, like under which constitution it is incorporated, then extract of the objects of the companies, then from how many years they are operating in India. All this detail has to be given in prospectus. 386 is consent. 388 is consent of expert. So before issuing prospectus to the public, then expert consent has to be obtained. Without consent of the expert, the prospectus cannot be issued to public. Then 389 is registration of the prospectus with ROC. So with ROC we should register at least 3 days before issue. It should be registered with ROC. Then 389, 390 is IDR, Indian Depository Receipt. The foreign company who is issuing the IDR should be listed in its home country. The share should be continuously traded. It should have paid up capital of $15 million US, and it should have a market capitalization of $100 million US. Then minimum 50 crores is the amount which they can issue IDR, and maximum 25% of the IDR can be converted into shares. So this is for an IDR. Then 391, if there is a misstatement in prospectus, then they will be punished under section 34 and 35, civil and criminal penalty. Then 392, any person violating a foreign company, he will be punished with 1 lakh to 3 lakh rupees of fine. Then 393 is like the contract with the Indian company will not be invalidated because there is a violation. So no contract will be invalidated. So these points should be understood in foreign company. Then we have section next we will go to government company, section 394 and 395. Government company means a company under section 2 subsection 45, which says company not less than 51% of the shares held by central government, state government, or combination of both, and subsidiary of the government company. So whether it is a subsidiary of a government company, it's a government company, or if it is held by government, it's a government company. You should not add you should not add government company shareholding with the government. Okay, so be sure with that. Then section 394 says in case the company is held by both central government as well as state government, after completion of audit, after C&AG audit is over, after AGM is over, within 3 months from the date of AGM, it should be filed with both houses of parliament as well as state legislative assembly. Section 395 says in case the state government is holding the shares and there is no central government intervention, then within 3 months from the AGM date, it should be filed with legislative assembly of the state. Then 396, this is ROC chapter, section 396. Section 396 says central government can establish ROC wherever they want. Section 397 says it's not necessary that physical form should be there. Electronical form can be substitute for the physical form. So there are many electronical forms like MGT, AOC, then PBT, DPT deposits. Then like that, there are so many forms. So this will be substitute for the physical form. Then these forms can also be inspected. Public documents can be inspected by paying 100 rupees. What are the forms that can be inspected means incorporation document, then director's details, other documents, e-form, then charges. All these things can be inspected by paying 100 rupees. This is 398 and 399. And 4 then you have that value added service. Then whatever the money which is collected as ROC fee will be deposited in public account of India maintained with RBI. Then 403 says 402. Then 402 says Information Technology Act will be applicable for Companies Act. So whatever forms will be filed with digital signature, etc., this Information Technology Act will be applicable. Then you have 403 additional fees. Actually there is an amendment in this section that per day 100 rupees will be charged, but as of now that amendment is not yet implemented, so keep in mind. So it will be additional fees, if there is a delay in filing of forms, additional fees will be imposed. Then you have statistics. 405 you have statistics. If you are not giving statistics to the government whenever they ask, they can have a right to pay penalty. Then 406 is Nidhi company. Nidhi company is mutual benefit company. It can be started only by individuals, and minimum 200 individuals should be there. The loan can be given only to individuals, and it can be taken means the loan, the deposits, the company can take deposits only from individuals, and the loan can be given only to individuals, and every person should be a shareholder. Body corporate cannot be a shareholder, and they cannot do some business like leasing, hire purchase, NBFC business, that all they should not do. And chit fund is not a Nidhi company. Nidhi need not be registered with NBFC under 45 IA of RBI Act. And Nidhi company can give dividends maximum of 25%. Then Nidhi company can have income from locker rent. That income should not cross 20% of the total income. Then so these are the points. Then unencumbered deposits, at least 10% of the total deposit should be in unencumbered deposit. Then 1:20, that own funds is to borrowed funds, own funds is to deposits is not more than 1:20. So these points should be kept in mind for Nidhi company. So please go through these chapters now and do the final revision. Okay, if you have anything to be discussed, please WhatsApp me. I will try to come and post a video before 10:30 p.m. Okay, all the best guys. Thank you so much.